And this matter comes before the court this afternoon on defendants Amy Tyrell as legal guardian of Lucas Tyrell and Amy Tyrell and David Tyrell's motion for summary disposition in lieu of answer pursuant to MCR 2.116C8. At this time, I would invite counsel to place your appearances on the record.
And I will start plaintiff Anna Wright, 72611. Good afternoon, everyone.
Very good. Good afternoon.
Sorry for cutting you off there. Amy Schrader, P87537 for the defendants Tyrell.
All right. Thank you, Ms. Schrader.
Good afternoon, everyone. Andrew Lux on behalf of defendants Calvin University, Abigail Sibazinski, and Lauren Horace, P number 87295. Your Honor, we did not file a concurring motion, but we are appearing today to witness the outcome of the proceeding.
All right. Thank you, Mr. Lux. And I do have I believe, no, but it's not yours. It's a couple of the other defendants ready for life, Tony Falk, Emily Purton. Or are they yours as well, Mr. Lux?
It's mine, Your Honor. Kate Mann on behalf of defendant Ready for Life, Tony Falk, and Emily Purton, P76606. And that's scheduled to be heard in August.
Okay, very good. That's consistent with what my notes say. So, all right. Well, with regard to today's, Ms. Schrader, I believe that's yours, so I will let you lead us off.
Thank you, Your Honor. So I would just like to start off by saying there were some problems we've identified in the pleading so far and in the plaintiff's response, specifically as regards to citations. So as we go through, there will be some citations where plaintiff has claimed that the standard of review creates one standard, but that's not actually the case for various reasons.
All right, I will trust that you'll point those out, and of course, I will give plaintiff an opportunity to weigh in on the issue. So you may proceed.
Okay, thank you, Your Honor. So to begin with, if we start with the counts 1 and 2, the assault and battery.
All right.
So I would just like to repeat that the standard should be, when regarding this type of motion, that conclusory allegations unsupported by factual allegations do not suffice to state the elements of a claim upon which relief can be granted. So there's some citations to case law, specifically Maiden v. Rosewood and McDonald v. Barbaroto, where plaintiff claims that, let's see the specific wording, the gravamen of plaintiff's action is determined by considering the entire claim. Now that quote directly from Maiden v. Rosewood is talking about the plaintiff in that case could not avoid the protection of witness immunity by artful pleading. It's not talking about the standard for reviewing a C8 motion in this case. That's an entirely different set of circumstances. And similarly, the McDonald v. Barbaroto case is about which claim to use when evaluating statute of limitations. It's completely irrelevant to the standard of review of a C8 motion.
However, I mean, are you taking issue with the general idea that I look beyond the procedural labels and determine the nature of the claim, based primarily upon the factual allegations?
I'm not trying to say you have to go with the horrible extreme of extreme formalism, but if they type a label, you've got to evaluate it on the label. No, I'm not sorry, excuse, as Your Honor says, I'm not trying to say anything that far. I'm trying to go with what the actual standard of review is, as Your Honor has said. And in this situation, I think on all of the claims pled, there has been deeply insufficient pleading, both of what the actual legal claim is and insufficiency in terms of at least one factual allegation supporting elements for each claim. So if we look at the assault and battery.
Okay.
So in plaintiff's response, there's an allegation that we're trying to say that because plaintiff cites the criminal code, that's the let's say the gravamen of our argument, that because of the citation to the criminal code, their allegation of assault and battery is insufficient. That's not what we're saying. We're saying that as pled, just looking at the pleadings, it's deeply unclear what plaintiff is actually alleging.
Well,
And
isn't he just simply the intentional tort of assault and battery, which is, at least last time I looked, a cause of action in Michigan law?
assault and battery is a cause of action in Michigan law, but I would say that under C8, the plaintiff still has to actually plead assault and battery. And that if you look at what their complaint actually says, assault and battery is definitely not sufficiently pled. If I can go to, all right, so both plaintiff and myself cite Espinoza versus Thomas. And the relevant part in that holding was a battery is the willful and harmful or offensive touching of another person which results from an act intended to cause such a contact. Now, that holding, the standard of battery in Michigan, is that the intent is a specific intent to cause a harmful or offensive contact, not the standard of some other states, I think Delaware, where it just has to be the intent to cause a contact and then the harmful or if the contact is harmful or offensive. It's that in Michigan, the plaintiff has to prove that the defendant intended to cause a harmful or offensive contact. And the pleadings in this case do not sufficiently allege that intent.
Okay, and I'm flipping to the general allegations in the complaint here, and looking at Lucas forcibly, intentionally, without warning, kissed Charles on the lips and made contact with Charles' buttocks, committing a sexual assault and battery. Now, leaving out there's no separate cause of action for sexual assault and battery. In the civil case, it would just be straight up assault and battery. Why doesn't that qualify?
Because it doesn't specifically go into the specific intent that Lucas had to cause a harmful or offensive contact. So it's alleging that he caused this contact, but it's making the conclusory assertion that it was intentional, but it's not saying he intended to cause a harmful or offensive contact. It's not saying that Lucas specifically intended that contact to be harmful or offensive. In Lucas's mind, any contact, this is beyond the pleadings, so just outside of this analysis for this motion, but in Lucas's mind, if Lucas was intending for there to be a contact that he thought was consensual, that would not bring this assault and battery claim into play. What plaintiff alleges here is saying that he made a non-consensual intentional contact, but the plaintiff did not actually allege that Lucas knew and specifically intended for that contact to be harmful or offensive.
Don't some contacts go without saying when they're on a person in a bathroom or when a person's getting ready to go to a shower? I mean, just like the jury instructions tell the jury they can infer it's raining outside. I can infer if someone kisses me without my permission as I'm getting ready to go in the shower, unless heaven forbid it be my wife, that's not going to be consented to.
I think possibly in some other circumstances that might be the case, but in this specific situation, we're looking at specific intent here. We also have to keep in mind that Lucas is an individual with developmental disabilities, and that was included in the pleadings. It is included in the exhibits to plaintiff's complaint, the guardianship order, and plaintiff did not at any point in their pleadings allege anything regarding whether Lucas specifically had the capacity to have the kind of intent to commit intentional torts.
Well, not that that couldn't be a matter for discovery and along the lines of an affirmative defense, but I don't see necessarily how, in a situation of notice pleading, how can a plaintiff, at the outset of a case know that much information about the individual?
I think he still has to have pled that Lucas specifically had enough capacity to have the ability to form the kind of intent required for any intentional tort.
I have to disagree with you there. I mean, just like you take your, well, they say you take your plaintiff as you find them. You also take your defendants in some cases as you find them. And in this case, it may be the case that he is disabled and unable to form the intent. But of course, the defendant or the plaintiff at the time of their pleading is not in much of a position to know that, it seems. But I think I understand what you're arguing. Why don't we take on the next element that you think ought to be dismissed?
Okay. So I think the third count is very clear that this is the exact kind of situation where this kind of motion is extremely justified, that this claim just simply does not exist under Michigan law.
Just the intrusion on seclusion?
Intrusion into seclusion does exist, but not in these circumstances. So intrusion into seclusion is a type of claim regarding intrusion onto information. So it's not a type of trespass claim saying that Lucas went into private space. It's saying if this were contrafactually a situation where you could have that type of claim, it would be something like Lucas went into Charles's space and secretly video recorded him doing something extremely private. It's about getting the information. It's about spying and getting information. It's not about the plaintiff has a right to be left alone. It's about, this is a specific, narrowly described tort.
What about window peeping? If I sneak over to my neighbor's house in the dark of night and I'm peering through there, or let's just keep me off their property. In fact, let's I guess I have to do something intentional or there to view them, but I do that, and maybe I video record them or some. Well, let's take video out of it. Let's just say I'm just looking in the window, or maybe I climb up on a highly situated tree on my own property, but the reason I'm doing all that is to try and peer into this window where I think I might be able to see my neighbor in a state of undress. Don't I intrude on their seclusion?
Let's see I think Your Honor is correct in saying if that would be the third prong of this claim, the obtaining of information about the subject matter through some method objectionable to a reasonable man.
Yeah, well, and I also am thinking, I think there's a case out there about, some sort of public venue that had stalls, but they had like some see-through or one-way glass in the bathroom. Well, okay, now even if I don't tape that, if I'm just standing back there watching people do their business in the bathroom, am I intruding on their seclusion in that sense? I mean, there is an expectation of privacy in certain spaces here. And I think you're trying to say to me, Judge, but that doesn't really extend to necessarily to a bed. This is a roommate situation. These two share a room. Someone entering another person's bed, and it may be conjoined with the assault case, of course. But, unless he's peering under the covers, and that doesn't appear to be here. It just appears to be this outright non-consensual touching that's the subject of the claim. That maybe the bed situation doesn't fit exactly with the facts in this kind of common law cause of action. Is that the argument?
I think that's very fair. And again, in addition to that, just as it is pled, it's not sufficiently alleging facts that suit the particular common law cause of action.
Okay, all right. No, I think I understand the argument there. Why don't we go on to the next count here, which I think brings us to 4, which is
the IIED against Lucas.
Yeah, okay.
I would just like,
go ahead.
Sorry, Your Honor.
Well, I was just going to say, again, the unconsented sexual type touching, there aren't too many things, granted, that rise to that level of outrageous conduct, but it does seem to me to be one of those that I think there's hardly much of an argument to make that if someone commits that level of conduct, and again, I think we have to just leave out the mindset of the defendant at this point because that's an unknown. But if that conduct occurs, uh, mm, what else do they need for a cause of action, I guess is my question.
Okay, before we get into that, I just did want to make a clarification for the record that in our motion, we do say on page 10 something about the plaintiff states the elements of this cause of action, but we weren't saying in our motion that we admit that the plaintiff actually alleged all the elements of the cause of action. Plaintiff brought that up in their response, so I just wanted that to be very clear.
Okay, no, and that's what I'm trying to drive at here is if
Yeah.
there are those missing elements, let me know what they are so that I can, well, because I mean, a key question here is, right, do I dismiss? Do I allow a period of time for amendment? If there are things that could be potentially amended to fill in, necessary blanks, or do I deny and say, well, this is notice pleading, we got enough here to go forward. So that's what I'm driving at. If we've got those missing pieces, I think this is the time to fill it in. So,
Yes.
all right. Well, let's continue on then to intentional infliction. What's missing in that portion?
Okay, so with regard to the IIED about Lucas, so if we could go to the specific element about whether plaintiff has alleged sufficient facts regarding plaintiff's extreme emotional distress, we would say in this specific case, although for the sake of this motion alone, even if we hypothetically conceded the first element,
The
we would still say
outrageousness, yeah.
we'd still say that the plaintiff has to give us sufficient factual allegations so that we have notice of what we're defending against. So in this case, the extreme act has to have an element, and then also the intent and recklessness or recklessness, then also the causation, and then also that the extreme emotional distress resulted. So we would say in this specific case, looking at plaintiff's complaint alone, they've not actually alleged the facts to show the extreme emotional distress. It's the same kind of vague and conclusory statements that are the result of that are listed as the damages for other claims in the complaint. But in order to successfully plead this claim, I would have wanted something showing actual factual allegations about the plaintiff's extreme emotional distress that resulted. So I'd want something saying,
He had to obtain counseling. He suffered from sleeplessness. He had severe headaches or flashbacks, or wasn't able to sleep because of the assault. Something along those lines.
yes, Your Honor.
Okay. All right. No, I think I understand that what you're saying. So, okay. All right. And now the parents, the claim of IIED against the parents. Let's move to that one because that one does, appear to me to certainly be more attenuated. It certainly is quite a stretch to think that these parents went beyond wanting to protect their own kid and wanted to intentionally harm the disabled kid who was the alleged victim here. Now, they may have downplayed his claims, they may have minimized them, but that's quite a bit different from saying, I'm going about this with the intent of causing harm. Is that what you're raising here? Is that even if as I have to accept all of the factual, well-pled allegations in the complaint, it still doesn't go far enough?
Yes, those two elements are our main argument against this one. I think we also mentioned the causation and the emotional damages as well. But
Sure, that the same
specifically,
thing would be true there, and one can imagine, well, it's kind of difficult, and in a case like this, to say, well, you can't sleep because this bad thing happened to you. You can't sleep because the other parents didn't believe you. That would be a pretty fine distinction for any kid to suss out. But I do get what you're saying and that's certainly a question I'll put to plaintiff's counsel. So, all right, and then let's move on to per se.
Oh yeah, I also did just want to reemphasize, as Your Honor said, that the actions alleged here are in any way rising to the level of anything that could be sustained in an IED against Amy and David. This is exactly the kind of situation that Michigan law doesn't want to have an IED claim coming. This is, if we could look at what the natural fallout of this would be, that a parent is liable for this kind of action anytime they don't automatically accept any sort of allegation that their kid has performed any activity. Like, look at if we're saying that the extreme and outrageous conduct was making statements not even to the plaintiff, but to other people, how are the parents ever supposed to behave in a normal standard of supporting their child?
Yeah,
And
no, I would envision this would be something more akin to, this dance moms type conduct where, the situation where one parent goes directly to the other child and says, you're not believable, and further, adds insult to injury, as it were. But I don't see those allegations in this particular complaint. So, I think I understand the argument there with regard to the parents. Well, and since we're on the parents, let's move on to negligence and gross negligence.
okay. So I'd like to start off just getting the gross negligence addressed. So
No separate cause of action for gross negligence. We just call it regular negligence, unless you need gross negligence to get around immunity or something like that.
thank you, Your Honor. Yes.
Okay, yeah, that's my perception as well, is that there's not a separate cause of action for gross negligence, right? And that it's a legal term that we utilize when you want to preserve what's really a negligence claim, but a additional level of negligence, an enhanced negligence is required, such as the governmental immunity statute or something along those lines.
Exactly.
Okay. All right. No, I think I understand that argument. What about the straight up negligence claim? And I would say that in this case, it looks to me like, well, perhaps both the supervision or, agreeing to, and I think there at least is some allegation here that mom steered, these two roommates together somehow behind the scenes, perhaps knowing of her son's dangerousness, but perhaps not. There isn't an indicator or any evidence contained in the complaint other than, maybe an inference there that you should have known. But of course, we all know as parents, it's not always the circumstance. You don't always know what your kids are going to do, and otherwise no parent would ever be shocked by a call from a teacher or another parent and say, "Oh, it couldn't be my kid." Oh, yeah, by golly,
Exactly.
that is my kid. So, yeah, no, I get it that it's hard to predict. And then I suppose the negligence claim also could be supported to a degree by their reaction to the allegations here that, in a light least favorable to the defendants. Certainly, what they're doing is perhaps prolonging the situation by saying, "Oh, well, maybe it was consensual," or interjecting some facts that would arguably, I guess is that, should I consider that as part of the negligence allegations or not?
I would say specifically what we were just talking about before, I'd say there's a problem that as regards an allegation that they had any kind of prior notice, there's no factual allegation regarding what these prior acts would have been. This all seems to be completely a posteriori assessment. But more importantly,
That means after the fact, right, Mr.
yes, Your Honor.
Okay, good. All right.
Let's see. I had a weird Latin pronunciation, probably. If we go to the element of duty, I think plaintiff is not remotely establish that David or Amy had any duty in this case. And this was one of the situations where the citations were not correct. So if we go to all right. Plaintiff cited forget my pronunciation on this one, Bukowski. And the citation is not correct. Let me see. Sorry, just going through my notes on this one. Okay, there we go. Right, so plaintiff claims that the Michigan Supreme Court opinion in Bukowski v. McKay imposed a duty of care on anyone who takes charge of a person whom he knows or should know to be likely to cause bodily harm to others if not controlled. Restatement, Second of Torts 319. That is simply not true. The case does not establish that standard.
And what is the proper standard that I should examine for a claim against negligence, some sort of negligent supervision, I guess, with regard to the parents?
That they have no duty whatsoever to the plaintiff. The plaintiff is an unrelated third party, and that there's no requirement under Michigan law that they have a duty to supervise their adult son, even with a guardianship order.
Okay, all right, or not. Now, I, in my probably infantile view of guardianship law, view a guardianship order as having the effect of saying, well, you have to step in and substitute your judgment for the ward's judgment because, the ward's judgment's lacking in some way, shape, or form, and therefore saying, well, maybe that would even enhance a parent's duty when I've got a guardianship, but that's just not the law in Michigan, is what you're telling me.
That's not the law in Michigan, no.
Okay. Well, oftentimes my musings are not. They're law in Rossi's head, but not in the state of Michigan. So, all right. I think I understand the arguments. Let me give plaintiff a chance to weigh in.
Thank you, Your Honor. I do have a whole argument prepared, but are there specific claims that the court would like me to address that the court is considering taking action on adverse to?
I would say gross negligence, as a separate count. I certainly seen things pled as it was negligent and or grossly negligent, but to add it as a separate count as a standalone cause of action, why should we go forward?
Sure, Your Honor. So again, the complaint alleges, and I want to preface this, that there are a few facts that defendants repeatedly rely on that are outside of a C8 motion. For example, that Lucas allegedly lacked intent. Lucas was under a guardianship, which I believe was a partial guardianship. Amy and David were merely acting as loving parents. Plaintiff's allegations are supposedly contradicted by other facts. These are factual disputes. And under the C8 motion, as the court has indicated, which briefly we touched upon, we have to accept plaintiff's allegations as true, construe them in plaintiff's favor. We cannot weigh evidence. We cannot decide credibility, and cannot resolve competing factual narratives. Again, this is a C8 motion, and this may be appropriate as a C10 motion later on, but certainly after discovery and not right now. Now, when it comes to the gross negligence, Your Honor, I guess when I look at the acts of Amy and Lucas, here is what was pled. Amy sought to remove references to penetration from the record. In essence, she instructed the individuals at the college to falsify records. We cannot make this motion about focusing of what a mother did for her son. That has no place here. This is a focus on what does the actual complaint allege. And that's one of the allegations that we've made. And it has to be considered as true. Amy and David attempted to recast the admission as consensual. So even after hearing that their son admitted to the unconsensual contact, they wanted to go back and say, no, it was unconsensual. These are outrageous conducts by parents. They minimize the conduct of their son. They wanted to shift the blame onto the plaintiff. And these are, again, allegations that we've made. Later on, defendant can say, no, the discovery does not bear this. I think otherwise, but they can make that argument after the close of discovery. And they also participated in efforts that allegedly concealed the true nature of this assault. These are outrageous conduct. And therefore, it bears the title of gross negligence as guardians of this individual.
Well, I certainly, I think that's a good argument for, perhaps keeping the intentional infliction of mental distress claim there against the parents. Although, do I need to require you in the pleading to come back and say, hey, and not only did they do this, but they did it with the intention not of insulating their own kid or salving their own conscience for their role in the situation, but rather specifically to hurt the other disabled individual involved in the case.
Well, I would argue that most reasonable parents would say, let's hire a good attorney. They would not say, I am instructing you not to put references of penetration into the record. I mean, I think a reasonable jury could infer that these actions can support a claim for IIED. I mean, and that's what we have to do. That's all we have to do is just plead them. They can go through the discovery and say, no, that's not true. But at the very least, at this point, we've shown enough to say that conduct, and a jury can make the determination that this claim could be supportive of IIED. I do want to reference the IIED claim that the court stated with respect to my client and whether we've proved that there was damage. Let's go back to the allegations supporting IIED against Lucas, which I think in terms of what has happened to my client goes for both against parents and Lucas. And we also plead repeated sexual assault, unwanted touching, penetration, fear, emotional trauma, reporting to school officials a specific conduct, crying, and feeling unsafe. These are all pleadings that were made in this context. That a jury, a reasonable person, or a juror could make the determination that that is our signs of IIED, at least on the emotional damage part and mental damage. I also want to bring the court back into count 3, intrusion upon seclusion. And I disagree with defendants. I believe that in Michigan, intrusion upon seclusion is broader than confidential record cases, as a defendant would like us to believe. The essence of the tort is an intentional intrusion into a private place or private affairs in a manner that is highly objectionable to a reasonable person. And as the court pointed out, even between roommates, I could see the court's argument in terms of the bed, but not the shower. I've had roommates in college. I don't think I would appreciate my roommate coming in as I'm taking a shower and walking in, and I think a reasonable jury could assume that is unwanted and it's objectionable, especially if the person walks into my shower and I, as the plaintiff, and in this case we did plead, he outwardly told Lucas, I don't want this. He pushed him off the bed to the point where his mother acknowledged that there was an injury on Lucas because of that forceful objection by my client. I think that survives, at least in the pleading stages, Your Honor. We've pled enough.
I think I agree with intrusion on seclusion. I guess I want to bounce back to that damages. Do I need to require an amended pleading to say more information? Because you've said, of course, and I think you're right, it's quite obvious that, a multiple time occurring sexual assault, even if, incomplete or attempted or whatever it might be, it goes without saying, well, of course that causes emotional distress. However, for purposes of a civil case, where you're going to try to recover some damages, do I need to require you to itemize, such as sleeplessness, repeated anxiety, the need for, counseling and, other, steps in his life? Does that have to be pled or, I think you're asking me just to assume it, and I'm not sure that that's going to be enough to get to the causation and damages point.
Your Honor, I'm not asking the court to assume it, but in fact, because Michigan is a notice state in terms of pleading, and Your Honor, this is, as defendants have pointed out, this was filed in federal court. It was dismissed in federal court. The federal court did not issue any rulings, and they did not exercise their jurisdiction as to the state claims. But my client was deposed, and defendant is acting as though they do not know what is going on, and they do not know that we are claiming rape. And they're acting as though they have no idea what the claims are about, when in fact they depose my client and they know that he went to therapy. All we have to do is put them on notice. They can, through discovery, once again, through discovery, they can look at the specific allegations in addition to crying and and discussing it with various individuals within the school. They can look at the therapy records and make the determination through discovery of his specific damages. Do I need to go through? Because that's exactly what I think they would like for me to do, is go through his therapy records and put them into the complaint. I don't believe that I have to do that at the onset. That is
No,
for
I
the
think
discovery.
perhaps just saying that well, and I guess, my guilt here too is that, of course, in some types of, in negligent infliction of mental distress, it certainly required that you show a physical manifestation of some sort of the emotional damage that you sustained. For example, I got headaches or sleeplessness, things that I've already tightening in my chest, whatever it might be. That you document that and plead it. I'm not sure that that's required for intentional infliction, because frankly, I don't see a lot of intentional infliction. Is it like trespass, where even a slight incursion or damage, we can presume it just from the fact that the act occurred?
I can answer that, Your Honor. So, as you say, there used to be a physical requirement. There's no such, no requirement to show a physical injury, but
Not
there
even for
is
negligent infliction.
but for intentional infliction of emotional
Intentional,
distress.
okay.
But there is a requirement, as we spoke about earlier, that plaintiff does still have to factually allege the extreme emotional distress, and that has not been done.
What about
And
what about plaintiff's counsel's reference to, gee, you went through a deposition, you got, some facts in addition to it. That we're going to come out and say he had to receive counseling, had to increase the therapy he was receiving, maybe medicine, whatever it might be. Is it really necessary to go through the exercise of listing it? And I think you're saying yes.
I think it is. I think we're entitled to have that listed. And also, I just wanted to briefly go over the third count. The
Can I
plaintiff.
finish
Well,
my?
let me, I didn't, I don't think Miss Wright was quite finished yet. So
Sorry.
I will give you a chance to argue again after she's finished. So go ahead, Miss Wright.
Thank you. Your Honor, I do want to make a record that I do not have to show intent on behalf of Lucas at this stage. I mean, I don't. I pled that he intentionally acted. And what did I specifically said? He kissed plaintiff without consent, and he knew that there was no consent because Charles specifically said to him, "Don't do that," and that was pled. He touched plaintiff's buttocks. He entered plaintiff's bed naked. He penetrated plaintiff without consent, attempted additional unwanted sexual contact, and I believe that's referencing the shower. And then plaintiff verbally rejected the contact and physically pushed Lucas away. Even if the title of sexual battery or assault is imperfect, Michigan courts examined the substance of a claim, not merely its label. Here, the allegation pled clearly intentional contact, offensive or harmful touching, and lack of consent. And that's all that I need to do. I do not need to show that this individual lacked intent. Furthermore, mental capacity is an affirmative defense and a factual issue. And nothing in the pleading establishes as a matter of law that Lucas was incapable of forming an intent. The complaint alleges intentional kissing, touching, entering his bed, penetration, and those allegations must be accepted as true. And the inquiry stops there, at least for a C8 motion. C10, after discovery, they can plead that we have not made the intentional element, but not as a C8 motion. And for the record, Your Honor, I do believe that what defendant is doing is couching a C10 motion into a C8 and seeing what sticks. And that's improper.
Nope, I certainly wouldn't want that to happen. And as I'm looking at this negligence and gross negligence count, I do note count 7 and 8 do say negligence and gross negligence, which is, I guess, not uncommon, even though, right, gross negligence, but it's not a standalone count, as it were. It's just incorporated into a negligent count, both to Amy Terrell in her role as guardian and parent, and then to both parents simply, obviously, just as their role as parents of the child. So, all right, well, let me return to defense counsel for additional argument.
Thank you, Your Honor. So I would like to say that I'm very aware this is a C8 motion. We would be having a very different discussion if this were a C10. So plaintiffs does still have to make factual allegations for each element, and intent is an element of an IIED. So the statement just then that she doesn't have to plead intent at this stage is not true. She has to at least sufficiently allege that there was intent for an IIED to survive a C8 motion. And
well, and I think she's asking me to infer intent from the nature of the actions, a non-consented kissing and non-consented sexual touching. Those aren't accidental actions; those are intentional actions. I don't think that's too far of a reach. Do you say it has to go farther in that he has to intend the result of the mental distress, or can he commit an action that's so offensive, perhaps not knowing the amount of mental distress or leaving that for a different day, but still sustain the cause of action?
So the law says that there are two different ways intent can go forward in this. So it either has to be a very specific intent to cause the emotional distress, specific to Lucas, or recklessness. However, as far as I'm aware, the recklessness standard has never in Michigan been examined with respect to someone who has developmental disabilities. I was not able to find case law where there was any holding that someone who has a lower standard of mental development, who maybe is not able to form specific intent, should be held to pure objective standard of recklessness. I'm not sure what the law would be on that issue. But in this case, also, I would like to point out that the partial guardianship order, which it's labeled partial guardianship, but it does assign all aspects of guardianship in the tick boxes, is included in the pleadings. It's an exhibit, and under case law is able to be considered under a C8 motion. I would say
that's included in your answer, or it's included in the complaint?
In the complaint.
Yeah, okay. All
Yeah.
right.
And I would say that this such situation, it is even more essential than in a normal IID claim for plaintiff to specifically allege what kind of intent is at issue. Are they saying that Lucas specifically intended for this to cause the harm, or are they saying he should be held to a pure objective standard of recklessness? That's something we need to know. That has not been sufficiently alleged.
All right. Well, both of you have argued this thoroughly enough and briefed it thoroughly enough to let me know that what I feel like I need to do is take it under advisement here. This is new to me, and I think that also potentially examining the claims against the other defendants and their elements might inform me better as to what my decision is ultimately going to be with regard to this motion. So I'll take the motion under advisement. My goal here, if I don't issue a written opinion prior to the arguments in August that I'm going to hear from other co-defendants, it's at least possible that I will be familiar with it enough by then to issue an order on the record encompassing all of the motions. So I guess that's what I'll shoot for, is certainly by the time we get to oral argument, at least resolve this one and potentially resolve them all via following oral arguments on the record. If not, I guess I would then take them all under advisement and issue a massive written opinion, though that would probably cause my research attorney to have a heart attack and quit before that happened in August. So I'm not sure that I'm going to do that either. I'd like to be familiar with it enough to issue an opinion on the record so I can do any necessary clarifications and do it while it's fresh in my mind. But I'll take this one under advisement until then.
Could I make a couple
Thank
more
you, Your Honor.
statements?
Yep, go ahead.
So I just also wanted to clarify, as with respect to count 3, plaintiff again made the statement that that was intrusion into a private space. This is, once again, as we talked about, it's a private subject matter. It's not a trespass claim. I think, as we discussed, this as pled is not a sustainable claim. It's in Michigan, we don't have what plaintiff was saying was this broad right to bring this cause of action. It is a narrowly tailored cause, and I do not think it was sufficiently pled. As respects to the outrageous act of the parents, I do not believe that any acts as alleged in that complaint are remotely conceivably possible to view as an outrageous act as judged by an IID claim. If this were a C10 motion, we would be leaving this to the court to say, make that initial determination before it even goes to a jury. Was this an outrageous act? And I think at a C10 motion, that would not happen. And at a C8 motion, it definitely doesn't happen. None of the allegations can arise to that level. If you look at the fact that there's no well-pleaded factual allegation that the parents had any actual contact with Charles making these statements. If you look at the case law, this is a situation comparable to other IID claims where a person makes a statement to another person and somehow plaintiff hears of that. This is not an outrageous act. Also,
Because I don't examine it in the context of what I, as a third party, would view as outrageous conduct, but what would be reasonably considered outrageous conduct vis-a-vis the recipient there in the relationship between the defendants and the plaintiff in this case, who was arguably injured, and perhaps felt terrible if he felt like some people didn't believe him, as oftentimes happens in cases involving children. That they would like everyone, of course, to believe everything they say at face value, and he might view it as outrageous, but that I might not view it as outrageous, for example. I think that's what you're arguing.
That a reasonable person would not view this as the kind of extreme and outrageous conduct contemplated by that claim. No.
Okay. All right.
Can I respond to that, Your Honor? Just
Yeah,
so that
go
the
ahead.
record is
Sure.
clear.
Yep.
We're not talking about gossip here. And I think defense counsel wants to say that this is gossip and that Charles overheard this.
No, I think the
as a
question
parent,
is that, well, let me redirect, because
sure.
I think, okay, a parent and the parent's trying to, if I take the allegations at face value, trying to, shape the school's records here and saying that doesn't say anything about penetration, right? Let's scrub that out of the record. Well, the question then becomes, if I assume, to get to intentional infliction, I need to assume she did that not with the intention of, right, as I said before, helping her own conscience or helping her own kid, but rather for the intention of hurting the plaintiff in this case, that was intentionally directed, or she knew he would gain that information somehow. And I don't think that's necessarily a guarantee or patently obvious from the way it's pled that he would ever receive that information.
Well, I think he would when he goes to look at those records and what was said, and the records do not reflect the truth of the conversation. And I think she knew that. And I think a reasonable juror, a reasonable person standard could say that that was outrageous conduct to ask a school official to change what really was the truth. And that's what we're talking about here. And so I think with that, when you look at it that way, I think she knew that that would hurt Charles. How do you not when there was a rape and now we're saying there was no rape?
Yeah, I can see, right. Certainly viewed like in that context, and if there was the near certainty that he would gain that information at some point, perhaps that would rise to the level. So I understand the argument.
I would say that that's not the type of action that is considered extreme or outrageous. That if we went with that interpretation, I can't even conceive of how many causes of action that would open liability. That's exactly the opposite of what Michigan courts desire with this cause of action. We don't want to be saying, I am committing an extreme and outrageous act outside the bounds of civilized society if I go, even for the sake of this motion, accepting factual allegations, if I try to get a school record to omit a word, that's not the type of extreme or outrageous act that is contemplated by this cause of action.
Yeah, and I think we're in danger probably of wading so far into the factual specifics that it would take it out of the the world of C8 in general. But I certainly can imagine, and having unfortunately handled neglect and abuse cases as part of my assignments here for several years, I certainly saw actions taken by parents where they were failing to protect their kids that I would say are pretty darned outrageous. So yeah, it can, and sometimes in an effort to protect a different interest, unfortunately, people do get somewhat misguided. And the question there is, are they required to? What's the point of that? Is it to injure the other person, or is it simply to forward a separate interest that, but I think they're inevitably probably wade into a factual, discussion, because I think probably there's an argument that you knew or should know that it's going to have a negative effect on the recipient of the information. So I think all of it, and unfortunately the facts here are, somewhat unique with two developmentally disabled adults in a college setting, especially made to accommodate that. It leads to, in other words, some situations that may not be squarely contemplated by the case law, just because it's not an everyday occurrence, like school bullying, for example, or unfortunately child abuse and neglect. So I think it does raise some unique issues. I'll take it under advisement.
Thank you.
Thank you, Your Honor.
Thank you.
Your Honor, do you require an order for me to submit anything?
No, not when it's under advisement. I don't need that.
Okay, Your Honor, just for procedural purposes, the court, the way that I understand it, will more likely than not hear the other motion and then issue a global order. That's kind of what I read.
Best case scenario, that I have enough time when I review that, now having at least some introductory knowledge to the case, that I'll be in a position to issue an order that encompasses all the issues, all the questions.
Great, thank you.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.